Yes.
Counsel, there is a lot of pressure. There's a lot of pressure on the state of Florida and on Jacksonville Sheriff's Office to bring justice for Charles McCormick and justice for Barbara Butta for the horrible crimes committed against them. And the defendant is not guilty because bad things happen to good people. You better believe that there's pressure. Because what the defense will have you believe is that these two crimes will go without justice, full justice, based on DNA evidence in multiple locations with a 700 billion times more likely ratio that is this defendant than anyone else in the world. And his phone records would put him every single step of the way exactly where he's supposed to be and totally corroborate what that other criminal said. If he ran from the scene and beat a woman to make sure he got hit. Innocent people don't run away and break into the houses of citizens on Townsend Boulevard because they're just along for the ride. We heard an hour closing argument from Ms. Schlax, and God bless her. She is upholding the defendant's right of counsel to zealously represent him within the bounds of the law, and she did that. And she spent 59 minutes and 30 seconds talking about Charles McCormick and about 5 seconds talking about Barbara Butta. Why do you suppose that is? Why were these crimes charged together? And Ms. Schlax is right that you're to consider their verdict separately. We considered all the evidence in the case. The evidence against Hakeem Robinson and the evidence against Leroy Whitaker for both charges together because you can't unwrap it. This is one criminal episode. And the evidence against Barbara Buckley 1,000% proves he was involved in the murder. Why else do you break into a woman's house and grab her and say, I'm going to hurt her? Why on earth do you do that? Unless you're with the big gun. And that's why it wasn't discussed. Because if you analyze this case in total, there is no reasonable doubt. She talked about the evidence is DNA. The evidence is cell phones. The evidence is blue, and the evidence is barter. She left out a really, really important thing. And that is your God-given common sense. Your ability as a human being to realize that 2 plus 2 equals 4. That you can make logical inferences from the evidence to speak to what the truth is. Not only Barter can lie all day from the witness stand, but you have judgment. And I'm going to go through a whole bunch of things that prove that Dominique Barter didn't lie. He is a liar. And a criminal. He did not lie. So first, I want to talk a little bit about the objective truths that have nothing to do with Dominique Barter or Abdul Robinson. The Addison family and ATK was dissed by the victim in 6 Block in a song making fun of their loved one. That limits the number of people in the world. Mr. Cooper is going to pull up proof. Ms. Schlack said there's no evidence that Scotty is involved in ATK. There is. The fact that his Instagram has ATK on it. You can just circle that straight to what I'm talking about. Life of ATK with big ATK written. Huh. And I know, listen. I consider Mr. Cooper far better at digital ethics than I am. You saw they did most of that. We threw a lot of stuff at you, and I did it, and these things are missed. I don't think the Schlacks was trying to misread from the same generation. But it's in there. The testimony is uncontroverted. Ms. Robinson, who we heard from today, said, oh, they're not just friends, they're cousins. They're blood, and we were all on that. Mr. Whitaker is in for a penny, in for a pound, just on motive. That should not be in dispute. He is objective that he is part of that group. Now, is he as big as Hakeem Robinson? No. Is he a rapper? No. He's with them. We see the pictures of them together. We see videos of them together. They are hanging out thick as thieves. So the number of people that were willing to kill Charles McCormick, who's showing up at an employment service, is limited. It doesn't mean it's Leroy Whitaker exclusively. No, it doesn't mean that. But it's limited. That's objective. Number two, that both defendants, and remember, the evidence against Robinson corroborates the evidence against Whitaker and vice versa. That's why we tried them together. And I agree with Ms. Schlack's point that the verdicts are separate. That's why we have two juries. But you have to consider all the evidence and see how all the evidence fits. Both the defendants had the opportunity. The whole point of the cell phone evidence, Ms. Schlack is right. It's not GPS. It doesn't put him everywhere at the exact possible location. What it doesn't do, it doesn't exculpate him. It doesn't show he's somewhere else. In fact, it shows that he is everywhere that Dominique Barber says he is. The cell phones. Mr. Whitaker's cell phone stuff is actually the TDOA, the bands, and that actually gives us a little bit more precise. And if you remember that testimony, he is at every location. He is at the Maryland Road, he is at Townsend Road, at both of them. Receiving calls, texting locations, all his phone. We prove it's his phone. We went over this, I'm not going to do it again. The Instagram for the defendant, this Instagram was verified with this number. And he has all these little selfie pictures. That's how we prove it's his selfie. And it's corroborated because it's going exactly what Dominique Barber says it's going. Again, this is objective. The selfie stuff is objective. It puts him at Townsend Road, and it puts him at the scene. And that stuff has nothing to do with Dominique Barber. Oh, and guess what? The Robinson evidence does the same thing. He turns his phone off with his real phone, his burner phone. The data is hitting on all the points it's supposed to be hitting. Corroborating everything. Objective evidence. We know that the Nissan car is the murder car. There is no dispute about that. The Nissan car that crashed is the murder car. That was trailed and followed by the police from the scene of the murder, from the dash cam, until it crashed on Townsend Boulevard and people started running from it. Right? And we know that the shooter fled from the car with the weapon. The same weapon he used to kill, and it's Hakeem Robinson, there's no doubt about that. The same weapon he used to kill Charles McCormick is the same weapon somewhere in Tree Hill Preserve. The same weapon he had in that video that you can see, the video, Bang It Up video, is the same you can see. And that guy ran out with his gun. He's got to get rid of the murder weapon. These guns are, I wouldn't say they're relevant, they're very important to prove the case. They're not the murder weapon. He took his murder weapon and got rid of it. And that is why Dominique Barber went and used his pistol You gotta use your own gun. Anyway. And so we know that there's 2 guns left. The murderer took the weapon, and we know that we found 2 guns in the car. Mr. Robinson was linked to the murder car in 3 ways. The shirt in the driver's area, his DNA in the driver's compartment, and the print on Dominique Barner's slide of his handgun. 3 different ways he's placed in that car. Whitaker was placed in the car in 2 ways. Leroy Whitaker was on both shirts. One of them was with Hakeem Robinson. Both of these shirts, whether they were worn or not, maybe they were worn earlier, maybe they were worn as masks to cover, we don't know that exactly. But we know that they were kind of balled up, especially the one in the front, kind of wrapped up right next to the gun. They're wrapped up, and they both have their DNAs on them. 700 billion times more likely. Okay? It doesn't just jump around. The DNA doesn't just jump around. So, that 2 shirts puts Whitaker in the car. He's in the driver's side and the passenger in the rear part. And Schleck said over and over again, there's nothing that puts him on to this gun, which was swabbed, tested, nothing was on it. So that means no one's ever touched it. Of course, DNA and fingerprints are sometimes tough to get. When you touch something, it doesn't necessarily mean something behind. Almost, it's not on top of it. It shows in the seat. And it comes right there on the floorboard. You can't sit in the back seat without touching that gun. You have to see it. And Leroy Whitaker's DNA on that shirt. There's no real dispute about that. We hear a lot of dispute about that. His DNA is on the shirt. A lot of dispute about it. She screams over and over again, there's no evidence. But if your DNA is on the shirt, the back seat, right, almost touching a huge rifle, that's pretty good evidence that that defendant had that gun. It's pretty good evidence if you use your God-given common sense. Robinson possessed the similarly unique firearm before the crime. We talked about that. Now this is, I can't stress this enough. I opened with this. But Whitaker and Barner were so desperate to get away from this crime scene that they broke in to a woman they did not know, a 57-year-old woman's house, and they left their DNA on her pajamas. But it wasn't just DNA. It was blood. It was blood on her pajamas. And the testimony from the DNA analyst was it was both a single source from the mixture. So I have to explain this. You're gonna find Miss Buckley's DNA on Miss Buckley's body and on her clothes. Right? If you're wearing clothes, you're gonna find my DNA. So she's looking for DNA foreign to the neck, the hands, and the clothes. She tests, or she thinks she can find DNA. It tests all tests for blood. Barber's blood and Whitaker's blood. But it's not a mixture of the 2 of them. be sitting with him for hours and hours leading up to all of this? Whitaker and Barner got picked up by Blue. We have the pin track. We have the cells. Blue pled to doing that. He said, Abdul Robinson, I came out, picked these guys up, and they got me on the hook for an accessory after the fact. These are undisputed facts. Robinson is right-handed, wore a black and gray hoodie, just like the one the shooter has. Robinson was very happy about the murder and liked to brag about it. The video proves that the descriptions of the shooter were all wrong. So let's talk a little bit about motives to lie. All of that evidence, I submit to you, we don't need one at all. But we still have to analyze what he has to say and compare it to the known evidence. Is he telling the truth? He is a liar. Why should he be lying? Those are two very different questions. Very different questions. So, Barner, first of all, this is a minor point, Barner and all witnesses, every witness, met with the prosecutors and the defense attorneys before testifying. We heard a lot of questions like, well, how many times did you meet with the state? Yes, that's implying that somehow Mr. Cooper and I are telling these people what to say. We're doing a real crappy job. We meet with our witnesses because we need to know what they're going to testify to. And you know who says it's okay to meet with your witnesses? The law and Judge Salvador. Quote, you will hear this later. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. Quote, Judge Salvador, when you're charged to hear this case. No witness should ever be discredited because they sat down and talked to both sides about what they would testify to if called as a witness. That is the law. So that means Barner shouldn't be discredited because he met. Dominique Barner, and this is a fact, Dominique Barner wants to get the best deal for himself. I don't think there's any doubt about that. He's doing this for selfish reasons. He's not doing this out of the goodness of his heart. He may say that. You know, I want justice. Okay, whatever. Talk a second about his deal. There is no evidence he's getting 20 years. Zero. That is the minimum Judge Salvador can give him. And she can give him life without him. Anything in between is her decision and her decision alone. This whole concept that we bought this testimony, that's a real bad deal. He just pled guilty, confessed over and over again under oath, 9 hours of deposition, confessed to multiple murders, and he knows that this judge can say, I appreciate what you did, Mr. Barner. I'll give you life. That's the deal they're talking about? To strike a good bargain? What kind of bargain do you strike with the state? But his plan, according to the defense, his plan is to lie. When we have that much leverage of him, Judge Salvador has life to hang over him. And he's going to go, you know what? I'm going to make up who did this with me. He's going to make it up. Leroy Whitaker had no idea what he was doing. Right? He was just sitting in the car. We tricked him. This is the argument. What if we find out evidence he was lying after pled and looking at life? How would that look in his sentencing hearing? Your Honor, Mr. Barner agreed to testify and cooperate, but he lied about who was involved in this case. He said Mr. Whitaker was involved, and he wasn't. What? That's where you have to critically analyze what Barner's saying. Of course, he wants to make sure that the truth comes out because it'll help him. Help him because the evidence will corroborate the truth, and all that pressure will get justice for these victims. Not makeup. Barner doesn't know that Blue's going to testify. Blue doesn't know Barner's going to testify. Well, maybe he did by the time he flipped. Barner didn't know Natalie Gant and Renata Boston were going to testify. Again, this relates more to Hakeem Robinson, but it doesn't. He says Hakeem Robinson is the shooter. He doesn't know Renata Boston's going to come into this courtroom, and Renata Boston's going to say, yeah, it was some dude, I got an alert on my phone, and some dude wearing a black and gray jumpsuit came crawling out, walking out of the woods, and some white girl was driving around looking to pick somebody up, and Natalie Gant, who is not, we have no leverage on her. None. Nobody's arrested, nobody's in trouble. Natalie Gant, just take a sworn statement once we figure out who she is. Take a sworn statement. Yeah, I went and picked up Hakeem Robinson from the exact same location that his phone's pinging that we have that little map. That corroborates Barner. And that means he's telling you the truth about all this stuff. Barner didn't know that the digital expert Latham was going to do a body morphology and conclude the defendant could be the person behind the mask. Same argument. Has to do more with Hakeem Robinson. This means he's telling the truth. When he says it's Hakeem Robinson, he doesn't know that we're going to spend $70,000 on some digital expert to go, yeah, kind of sounds like him, kind of looks like him, it matches. It's consistent with it. Barner didn't know that we would be able to link Whitaker's phone through Instagram and prove everything that he testified to. Barner couldn't have known that the cloud would capture proof that Robinson's burner phone was his and would link Robinson to the murder. I mean, for all of Dominic Barner's issues, I don't think his brilliance is going to be argued by anyone here. So he's supposed to know all this stuff and predict it? Barner could not fabricate the DNA evidence. He could not fabricate the print evidence. That is overwhelming, and it proves this defendant's guilt. Barner didn't know that Robinson's known cell phone would be turned off during the murder, but his cell phone data from his the cell phone from the burner phone would be hitting off the towers. He also didn't know that the cell phone data from the known phone, which we remember when we did the Google searches from the Google plots, and the analysts said we don't do that because the data is 95 to 98% reliable, and that's not good enough for us, so we don't chart where the data is because we know there's some anomalies. We know that there's some anomalies, so we can chart that. But the defense went up and put the numbers anyway. You know what that shows? It shows that the known of defendant Robinson was at Dominic Barner's house picking him up and then driving to Atlantic Boulevard where they picked up the Nissan Sentra. And then it magically turns back on when everyone's together and all the crime is over. Kind of interesting. How does Dominic Barner know that? So let's talk about the principal instruction. So we heard that over and over and over again. Mr. Powell's going to pull that up. So again, using your common sense, this is how we prove it's a principal on Charles McCormick. Right? We're past the burglary with that. That's proven beyond reasonable doubt, and that is really, really, I submit to you, enough evidence to prove the murder, because nobody does that to an innocent woman unless they're fleeing from the police for a reason. But let's analyze it a little bit more. We know that they were all together for hours. This plot is all night. They're actually sitting in the apartment of Charles McCormick waiting for him. They didn't kill him. They were sitting there for hours. It was like a stakeout. Unfortunately, they're not as good at the police at doing stakeouts because they got distracted and they're playing with their phones or whatever it is. They miss McCormick leaving. But they're there for hours. Mind you, with all these guns, this rifle is not concealable. Hakeem Robinson's pistol rifle is not concealable. They're all sitting in there. Having a conscious intent of the act be done is like going to a football game, being invited to a football game. Hey, we're going to a football game. You want to come? And it's driving all the way to the stadium, sitting there for 4 hours, shaking a pennant in the air, watching the game, having to come out. I didn't have a conscious intent to go to a football game because I didn't say I wanted to. Well, I just sat there and cheered. So, we all know they were together stalking the victim. We know that there's a huge rifle in the back seat that he could not have missed. Whitaker, and this is an interesting point. When the crash happens, Robinson goes his way. As the passenger side, the driver and Whitaker both go together. Whitaker is leading. Whitaker does everything from that point forward in terms of getting them away. He jumps over the fence first, presumably cutting his leg. And Barber's right with him. And then they follow each other, Whitaker leading, into Miss Buckley's home. He is leading the escape, leaving his blood unmistakably on her leg. Barbara Buckley's testimony proves to you why are we in this woman's house? What just happened? Why did we shoot that poor man in broad daylight on Merrill Avenue? He's like, hey, you want me to hurt her? Brother? You want me to hurt her? Barbara Buckley doesn't hear a word of animosity, doesn't hear a word of fighting, doesn't hear any conflict between the two. And both of them working together and in conjunction proves what Dominique Varner says. It proves that the defendant is a principal, because what's the common sense? I just witnessed a murder I had nothing to do with, and now I'm breaking into a woman's house to get away? Am I going to work with the person that was obviously in on it? Driver? No. No. They were picked up together, both wearing the Buckley pajamas, having both left their blood all over Miss Buckley. Working together as principals. And they all have the same motive. We all have the same motive. A couple points about the DNA. The defense says, oh, it's flimsy, 700 billion. This is science. This is scientifically accepted in the community at large. This is what DNA evidence is and has been for decades. This is the statistical certainty that they can provide, which is much lower than the actual statistical. Remember, she said it's way more than 700 billion, but we only provide the 700 billion. If you try to count to 700 billion, it would take you 25,900 years to get to that number. You would count 1, 2, 3, without breaks, never sleeping, never drinking, never eating, never dying. It would take you 25,900 years to get to 700 billion. There is no doubt that the blood is the defendant's, DNA on the shirts is the defendant's. There is no doubt. 3 people, 3 guns, couple of small points. The search warrant of the Whitaker home, he's arrested months later. Remember, we didn't arrest Whitaker for the burglary with assault or battery because we didn't have the DNA for months. Hakeem Robinson was developed as a suspect very early because of the fingerprint. We had those results within a day. That made it to Jackson Sheriff's Office lab in the Senate. The DNA took months. Once they were, there's no reason to get a search warrant months later, try to find something. All that time he was out, he had the ability to delete, to get rid of phones. We don't have his phone. To get rid of clouds, to do all kinds of things that he wanted to do to make sure that evidence wouldn't be discovered. Wires and putting people together. The defendant was in jail, charged with a crime that we are trying here today, and had a lawyer appointed to him. He had counsel appointed. So all these neat little tricks that they think we can do, stop by having a lawyer, and he's charged in this case. You know, they say that Barner is a bad liar. He's bad. He's a liar. Okay. Then she spent about 20 minutes at the end of her closing saying how Barner doesn't say what my client did. Why on earth, if he's lying about all this, would he not exaggerate? Why doesn't he just say, yeah, I'm down for it. He told me, let's kill that guy. That's not hard to remember. I'm going to kill that guy. I'm not doing this thing much. He doesn't say that because he doesn't remember it. He's not bought and paid for. He says, listen, I know he's down because we sit in the car in an apartment complex for 3 hours, hours and hours waiting for this guy to get out. We're all holding guns. That's why I know he's involved. Remember, he doesn't have to say. The principal instruction is act. By word or act. He doesn't have to say, all right, let's all huddle up. This is what we're going to do. All he has to do is be there, clap out of the huddle. It's a really good analogy. Think about this. God orders call and plays. Everyone's in the huddle. Trevor Lawrence says, we're going to run off tackle right side to ETN. Everyone goes, ready, break. Who talks? Trevor Lawrence. Everyone will. Most everyone's on the same page and they don't jump offside and they do it all right. That's exactly what happened here. That is what the principal theory contemplates when it says word or act. Beyond and to the exclusion of a reasonable doubt, maybe the defendant is just the most unlucky person on the face of the earth. That his DNA is everywhere, that he didn't know anything that was happening, and everybody's just coming in here and lying on him. He's just guilty. Beyond and to the exclusion of a reasonable doubt is not possible doubts. It is not x-ray machines at the airport. We talked about that in jury selection. When you have a blow dryer or a gun, the person who's checking the x-rays has an absolute duty to confirm what these things are. Right? How are we going to do that other than the presentation of all of this? We don't have a time machine. The law doesn't contemplate all doubt. If there is a possible doubt that a gun is getting on a plane, you don't let it on the plane. That is not what the law contemplates. The law says that such a doubt should not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. Reasonable means logical, well-founded doubts. That's what reasonable doubt means. Reasonable doubt, I agree, we have to get you across the river. It can mean that the boat gets wet. It can mean that there's a hole in the boat, but you still get across the river. That's what reasonable doubt is. We have to show you through common sense and evidence that this man was a participant in the murder of Charles McCormick and beat and battered Miss Buckley when he entered her home to escape the police. And when you combine all of these pieces of evidence as one and analyze Abdul Robinson Sr. and analyze Butta and say, I don't like him. Arm, they say, checks out. Then you have an abiding conviction. It is the same level. Proof is the same as if you steal a pack of gum and you commit first-degree murder. It doesn't change. Not proof beyond possible doubts, all doubts, shadow of a doubts, but well-founded, logical doubts. That is what a reasonable doubt. And you can have pride when you convict this person It's the right thing to do, based on the law, and based on the evidence. Because he's guilty. He's not the unluckiest man on the face of the earth. He just was in for a penny and in for a pound. And did everything he could for that. He didn't count the trail of evidence that he would leave behind. He didn't count on Dominic Barner and Abdul Robinson coming to this courtroom. He didn't count on the cell phone records and Instagram records that would prove where he was and what he was doing. He didn't count on the Yaxi nucleic acid and how the tiniest little bit that you leave behind can be discovered by forensic examiners. Didn't count on any of that stuff. Hardest part about doing this is knowing that Charles McCormick's family and Charles McCormick, nothing that we do here will change that. He will forever be as he was on that slab of metal. But what we can do is we can provide answers about who's involved, about who's responsible. The totality of this evidence screams that Leroy Whitaker is a responsible murder. You'll have pride, your jury service, individually, collectively, find that body conviction you feel, check that box, says guilty, hold that man accountable. His role.
All right, thank you, Mr. Mizrahi.